Boa noite, pessoal. Luísa, você tá... Você me ouvindo? Tá o áudio aí, tá beleza? Como é que tá? Gente, por favor, um feedback. Oi. Ah. Alright, guys. So, let's start from... Well, now I can see my books are a mess. Okay. Yeah, nice. Before we begin, first, I want to apologize because I still owe you some material I had promised last week, but this week wasn't possible for me, guys. I'm really sorry about that. I've been working too much, both with pajamas and in the office I work for, and also as an autonomous lawyer. So that's been rough this uh, this week. But anyway, I'm finally finishing the material to send you. It's actually full of links to interesting websites, indication of a very good dictionary, a very good one. Also, two courses that I think are interesting if you want to pursue these studies in legal English. Okay, there are self-studies courses, and they're good. They're good. They're clear. They're they're well put. Like the method is like easy to follow, things like that. They are well structured, you know. So for this class, I'm looking like to my left side, your right side, whatever, because I have another computer here, and I brought this little text for us. This case, it's a court order. Okay, we're going to. It's actually a pretty basic order. It's an interlocutory order. It's not a final ruling or a final decision. But what I like about it, it's because it's a daily thing. Okay, whoever among you has worked with in courts here in Brazil, you'll immediately recognize this. Like the guy asked for the waiver of fees. The waiver is like the exemption. Okay, like he asked not to be charged some court fees. We have a name for this in Brazil, which could be roughly translated to English by free jurisdiction. So this guy asked for it. In English, they at least in the United States, they use the Latin term for it, which is to proceed in forma pauperis. That is, without paying the filing fee. And the court grants his request. He gets it. So he can proceed with his case without paying the fees, right? That's what we're going to discuss. I like this decision specifically because of this a matter of factness about it. I think it's really, it gives an insight in so many things that are going on there. You know, it's much better than to take, for example, a very exceptional Supreme Court decision. Okay, Our goal here is not is more like to have this insight on day-to-day legal reality in English. Okay, well, that's actually court reality. We know that legal reality supersedes that a lot. But anyway, okay, now before we actually begin, this is the case I'm going to present you. I'd like to tell you two or three things. First thing, um, well, to forget things on the first thing is not nice, right? The first thing is that Louisa from CAP asked me to tell you we're going to have a certificate. Okay, so but you've got to stay tuned. Come on, guys. That's only fair, right? So stay tuned because at any random time, Louisa will come up in the comment section and release a web link for a Google form or something like that that you will be able to fill, and then CAP can issue your certificate. Okay. Also, the second thing is that I've been questioned about it, and I think I actually owe you an explanation. In the beginning of our last session, the session in last week, I refuse to call it class, you know. In the beginning of our last session, I have mentioned that our legal English endeavor in 2016 was a flop. Okay, I've been specifically questioned about this wording of mine. Okay, I must make clear that the course itself was not a flop. Okay, it started with 3 students. Then one of them, for personal reasons, had to abandon the, the course. But we continued throughout the whole semester with really prolific, really cool many times, really cool and fun discussions on lots of different aspects of our legal lives. The thing is, what was a flop was that the initiative didn't go on because of the lack of interest in general interest from students, basically. Okay, the course itself was great. Okay, it was really nice. I was right before now, this afternoon, I was checking some of the texts I sent the girls, and it was a really nice time. So it wasn't a flop in this sense. Okay, it just wasn't popular and didn't go on, didn't have the success we expected. So yes, Larissa, we should please ask Kathy because it's out of my hands. I mean, I've already told them I am available to tackle it again. It's really interesting. I learn a lot, also because when you teach anything, you learn a lot from questions from whatever, and it's cool. It's actually cool. I've been an English teacher for 10 years, and I've never had the opportunity um, of in a classroom having it applied so evidently. You know, so it's really nice. Well, so enough is enough. Let's actually begin. 10 minutes for notices. So, first thing, let's remember some things we have discussed. Last week we were discussing jurisdiction. Do you remember it? Because, well, I know I know students. I've been a student, and I know students have like this short memory. But anyway, we've been discussing jurisdiction, and we saw that the structure is similar to what we have in Brazil, but different in its own ways. Similar in that in the United States there is a federal judicial system and a state judicial system upon which states have all the power to decide. Okay, that's really important. It's federalism, right? It also happens in Brazil. You know, our TJs, they are completely autonomous. Well, not completely, because there is a constitution and some laws they have to abide. But they are autonomous. And we saw that in the definition of jurisdiction in the United States, that's more specific than here in Brazil. Okay, in the definition of jurisdiction in the United States, if you want to go to a federal court, basically you're discussing a matter of federal law, okay, which we're not going to see now. Sorry, guys, we don't have time for it. But the difference is like matter and scope of of the law. Okay, that's what actually defines a federal law. Pretty much like here in Brazil, but there is one or another twist to it. I'm not going to get into it now. And also you have like this divergence of citizenship. That's when you have, for example, a case against a foreigner against foreigner. That's so old-fashioned. When you have a case between two people that are from different nationalities, okay, that's when you go to the federal court. I was going to bring you a case of a guardianship case, like parents on a dispute as to who is going to keep the child, but I couldn't find it. Sorry, it's actually creepy. I was certain I had it. But anyway, I brought you one. It's a really fun case. I brought you one that was filed in California. Okay, the first thing you're going to notice if you can, I think that on the description of this video, Luisa has made available a Google Drive folder with all those with the files I sent you. One article about uh, state versus federal jurisdiction, and this specific case, which is Lambesis versus Abiaro. It was filed in 2015. What is the case? Basically, this guy got arrested. Okay, this guy is Tim Lambesis. Is there any As I Lay Dying fan here? No, right? Because it sucks. As I Lay Dying is a heavy metal band. It's a metalcore band. It's not heavy metal. No. And they have this. They had uh, Okay, so we have a we have an asylum dying fan. Sorry about the knock metal thing. I'm a destruction guy, can you see? So anyway, Tim Lambesis was the lead singer for As I Lay Dying, and he was like this buffed up guy, so like really, really strong and all. And he got arrested because he assaulted his to assault guys. Well, now that we are in a how can I say in a higher level of discussion, to assault is a false cognate. Okay, to assault is to physically harass someone, usually provoking injuries, but not always. Uh, it is a crime. Okay, assaulting is crime. Actually, it's a misdemeanor. Battery is crime, but whatever. So he got arrested. Okay, and in jail he continued to work out because he was like this bodybuilding guy. But he used to take steroids. You know, steroids, like those things you inject into your body so that you grow exponentially, usually. And when he got to jail, he saw that he began to develop breasts, like women's breasts. Well, for him that was unwanted. Okay, and I was reading about it. It's actually a very common thing among people that use steroids. Like the hormone tax is so huge that that many men develop breasts, unwanted breasts. Of course, there are transgender men who want breasts, and but in this case, don't use steroids anyway. Okay, steroids are bad for you. There are other hormone treatments. Okay, not going into this matter. But the thing is, he started to develop breasts as a collateral effect of steroid abuse. Okay, and as he was an inmate in a Californian rehab center, a judicial rehab center. Okay, because he was arrested. He was There was a doctor who's responsible for him. A doctor, a nurse, and a psychiatrist. Yes, Mary Abiaro is the nurse. Okay, usually it's the first name against the first name. So Lambesis versus Abiaro. Mary Abiaro was the nurse. There was Dr. John Doe Pace. Okay, the doctor itself. And so who was responsible for him? That was They were the people responsible for him. So he filed a civil complaint. A civil complaint. Okay, that's not the writing. Well, when you complain about something, that's I didn't write that down because come on, guys. Okay, it's a complaint. He filed a civil complaint in, let's see the name of the District Court of Southern District of California. So again, remembering jurisdiction, right? There's the Supreme Court in federal courts. Okay, there's the Supreme Court. Then there are the courts of appeals. Okay, or the appellate courts. You can use both names. Let me write down this word, which is interesting. Appeal. Okay. To appeal is to take judicial action against a court ruling to which you do not agree, or with which you do not agree. Anyway, there's the Supreme Court, the appellate courts, and the district courts. In the federal judiciary system, there we saw that there are 13 districts, something like that. Okay, but in the state judiciary system, I haven't even bothered to study the Californian system, guys. I'm sorry, but come on. Each state has its own rules. So if you go to California, just feel free. Usually you can find in the state's website. You know, like Minas Gerais has a website. So California does have a website as well, and there is a section reserved for its judiciary system. Anyway, so there are those district courts, and that's where this case was filed. Okay, that's the base, the first degree. We call degree. We usually have 3 degrees, right? The district courts, the appellate courts, and the superior or supreme courts. In the United States, they do have a 3rd degree in the states. They have like this. I forgot their names, but it's like it's not Supreme courts. It's like state Supreme Court, something like that. Okay. Anyway, this guy filed this complaint because, and that's something interesting. A complaint you file in face of a tort, okay, or a crime or misdemeanor. A misdemeanor is like a small crime. Jogo do bicho is every criminal law teacher, criminal law professor we have gives us the example of jogo do bicho as misdemeanor in Brazil. So you can complain against torts or crimes and misdemeanors. For example, if someone hits you in the face, you file a criminal complaint. Okay, that's the point. There are 2 things we have to keep in mind here. The first thing is what I said last class. You don't have abstract jurisdiction in the United States, nor in England for that matter. Okay, you don't. That is, you can't, for example, file an unconstitutionality action against this given attitude, this given law that Congress has just approved. Okay, it doesn't happen. You can, however, file a constitutional complaint or a constitutional, there's another name for it, which I forgot. It's complaint, so it's not criminal and tort only. You can file a unconstitutional complaint against the application of a law, okay? So, for example, yeah, you got it, right? In this case, that's very very specific, okay? He said, okay, the doctors that doctor and the nurse that were looking after me, they neglected me. That's his case, okay? They neglected me, and then I'm filing this complaint. Remembering, and the second thing we should remember, the subjects. A tort is a civil wrong, okay? And well, and a crime is a crime. But the thing is, in this case, if this specific case proceeds, his requests, all his requests are granted, eventually the nurse and the doctor could be convicted for crimes because no, that's injury. Okay, their neglect caused injury upon another person, even though it's not a direct injury. It's like it's a side effect from a chemical. Well, injury anyway. But well, let's go. So if you open in the first page here, you see that Tim Lampesis, his name is Timothy. I find it's kind of cute, you know, like this huge heavy metal lead singer. It's called Timothy. That's huge, right? But anyway, sorry guys, I'm just not used to. I don't think I have the maturity to present these kind of things. So the first thing, he files a complaint against doctor and nurse. It could be against, for example, the state. In many cases, in movies, for example, I'm certain you've seen New York versus Smith. Okay, that's possible as well. Okay, because states have legal capacity. Okay, that's one I'm going to write down. Legal capacity. So, a legal capacity is like the faculty or the ability or the standing to be on court. Okay, for example, a child doesn't have legal capacity for most things. Anyway, and here it says Timothy Peter Lambesis. See, DCR is like the it's like the name of the form he had to sign, okay, to file the case. These registration numbers, guys. I'm sorry, but I'm really not going to explain them. Just ignore them, okay? He stands as the plaintiff. That's different, right? And Mary Abiaro, the nurse, pays John, no, well, John Doe pays psychiatrist, doctor, whatever. Uh, they are the defendants, okay, Abiaro and Pace. Check it out. A plaintiff in the middle of the page here. The plaintiff is a person who goes to court to file a complaint or a case in court specifically. Okay, guys. Last month, okay, I'll just release it. Otherwise, I would just tear it off. Last month, we had a serious problem in the office I'm working with because we were reviewing and proofreading some translations that were to be sent to England, and but the case itself is not yet established. Okay, we are in a phase. I'm not going to get into details, okay, because I have this undisclosure agreement I have to respect. But the case itself is on a conflict of jurisdiction case. The judges are still deciding whether they're going to try the case or not. Okay? So, in this case, we don't represent plaintiffs, okay, because the case doesn't exist. That's really important to remember, okay? Because like it was over 5,000 pages of documents we had to correct plaintiff or claimant, among other things. Come on, don't make this mistake, okay? A claimant is a person who has a claim. Remember, did you have classes with Arnaldo in Vetusta? Well, remember him if you had classes with him, because when he talks about subjective rights, things like that, that's the point. Okay, when you're a claimant, you claim to have a right to something or to receive something. Okay, so we have some other classmates. So claimants are the people whose rights are under attack or whatever. Okay, that's a claimant. You possess rights to something, or to be ordered to receive something, or whatever. A plaintiff is in court, basically. Okay, so Tim Lambesis is a plaintiff, Adiaro and or Pace, whatever, are defendants. He has filed a civil rights complaint pursuant to 42 U.S.C. paragraph 1983. What's that? I mean, I thought I knew English, but then they start writing in Greek. Well, the thing is, 42 U.S.C. paragraph 1983. I'm not sure if it reads 1983. Okay, it's not a date. Anyway, the thing is, USC is the United States Code. Remember when this time I don't think it was Arnaldo who told me, but I had a professor who told me, oh, in common law systems, they don't have codified law. Nah, it doesn't work like that. Okay, there is a code and it's huge. It's like our civil code or civil proceeding code. This United States Code, it establishes exactly what are going to be the functions of each of the judiciary members or whatever, and courts and procedures, proceedings, everything is there. Okay, so there is a very important code in the United States to establish how legal proceedings are going to happen. Okay, where they're going and all. This very second section is about complaints, I think. I've read parts of it, but I've stayed mostly on section 28, which is about the waiver of legal fees. Okay, but anyway, there is a code that establishes pretty much everything from what gives you the right to pursue a claim for free judicial relief or the attributions of the FBI. Really, there is a section for it, okay, in the same code. So, so pursuant to is a very common expression. Pursuant to. Pursuant to 42 U.S.C. paragraph 1983. Pursuant to is according to. but don't use pursuant to I don't know, Machado de Assis and Quincas Borba. Don't use that. Pursuant to is according to what was established in law. Okay. Pursuant to, that is following this rule. Okay, that's the use we have for pursuant to. So pursuant to Article 5 of our Constitution, all manner of come on, Article 5, guys, remember something, please. It's so big. Pursuant to Article 5, item, I don't remember the item, no person shall have jurisdiction denied. Okay, that's the use we have for it. Okay, pursuant to 42 USC, blah blah blah. Oh no, John Doe and Dr. Pace are different people. So he claims that they acted with deliberate indifference. That's a nice name for neglect. Okay, it's interesting that I remember reading when I was presenting this case for my students years ago. The elements of there are elements of guilt in certain attitudes or acts, and they coincide with those we have in Portuguese. Neglect is one of them. Neglect, recklessness, which is like when you say, "I don't give a fuck, I'm going to drink and drive," whatever. And the third one I always forget. No, I'll remember it. Well, so they acted with deliberate indifference. That's the definition of neglect to his serious medical needs in May and June 2014, so a year before that, by denying him medication which had been prescribed for him prior to his incarceration. So basically, that's his case. You see, it's not what I told you last week. It's not complicated English, not at all. Okay, there are some technical things, technical expressions, because pursuant to is different linguistically speaking than according to. Okay, according to is like an opinion given. No, pursuant to, you're following an order, you're following a mandate, you're following a rule. But you see, it's really direct, short. Okay, it's not complicated. That's if I wanted you to take this one thing with you from these 2 hours and remember to the rest of your lives, is that less is more. Okay, guys, keep it simple. So they denied him medication which had been prescribed for him. Well, so he seeks, to seek is to request, okay, but he aims at having, okay. In some cases, how can I explain it? It applies also to Brazilian law. You don't um, you don't really ask, you don't really request for an amount in damages unless you can prove specifically what those damages are. For example, moral damages. You don't say, "Oh, I want $1 million of moral damages." Nah, you don't do this. Okay, you give suggestions to the judge, whoever. Okay, you seek this. That's the point. So plaintiff seeks 35,500 Dollars? No. $1 million. Okay, that's a big amount. Aim to the moon, you might hit a bird. Uh, in general, and punitive damages. I don't know if you're familiar with that, because Brazilian jurisdiction is more and more coming to terms with it and adapting itself to begin applying it. Punitive damages, or how do I say, damages. Well, first of all, let's go like parts. Damages in its legal sense is not like the damage you do to a car, to a window. Okay, when you say damages, always in the plural. Also, it's like the amount you get paid in terms of compensation for the damage you suffer. Okay, so general damages involve either pain and suffering, which are moral damages, okay, which lead to moral damages, and also physical damages when you get an injury, which is this case. Uh, by saying general damages, that is both moral and physical damages, okay? And punitive damages, that's the kind Brazilian law is adjusting itself to. It's basically a damage of an amount in damages in order to how can I say, to hamper, to impede, to stop someone from repeating this said action. So a very, 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 very famous case is the McDonald's one. Have you heard about there? I think there is a documentary. I haven't seen it, but I've heard about it. This lady, I don't know where in the United States, but this lady got burned with her coffee. Ooh, who never? The first thing I imagined when I saw it was, well, come on. First thing I thought was like, oh, come on, who never gets burned with a coffee? But then when you look at the case, really, he got burned and got like millions of dollars. Yes, for compensation. And I thought, well, okay, those judges must be like crazy or stupid. But no, when you take a closer look at it, you see that, how can I say, that it was a repeated action by McDonald's. Over 20 people in that year in the United States had gotten like, it wasn't a simple burn, it was a third fucking degree burn. Okay, it was like the burn. That lady, I think she lost sensibility in her genitals for the rest of her life. It was like really a serious thing. Okay, so, and she wasn't the first, and she wasn't the 10th. Okay, there were many people who were suffering from those burns because McDonald's used to back then. It used to deliver their coffee in an extremely high temperature, like much higher than the usual coffee you get burned with. And they didn't tell people because usually people went like through drive-throughs, grabbed a coffee to go to work, and just open it up 40 minutes later, whatever. So it was still warm. Now you can imagine the temperature it was when it fell on this woman. So aside from that, she got like this, we say indemnity or compensation. I prefer, let me write it down. indemnity. Okay, you can use it as a regular verb, indemnify. Okay, McDonald's indemnified the woman in millions of dollars. I think the amount was actually never disclosed. But anyway, I prefer compensation. I think it's more elegant. Indemnity sounds like, yeah. Anyway, I forgot what I was going to say. Sorry. Anyway, she got millions of dollars of compensation after she was burned by the coffee. But when you see it, like she was like the 20th or 30th person had been burned. And the thing is, those millions of dollars, most of that were punitive damages. That was the United States judiciary telling McDonald's, well, um, McDonald's, just stop it. Okay, and kind of worked. Because imagine that. It works for big companies. Imagine Vivo or Oi. They pay compensation for unlawful charges. For example, when they charge um, a higher price on your phone bill than what you used. So they pay it for thousands of customers, but it still profits them. So punitive damages is a way to make big companies think over their actions or policies in some cases, okay? Um, which, again, it doesn't really make sense for a guy to ask for $35 million worth of punitive damages. Probably in this case, I haven't gone really deep into it. Probably also because since he is incarcerated and the state is responsible for him, probably because these people are not individuals, but they have a joint liability with um, with the state, okay, the state of California. Liability is the legal responsibility. So when I say I'm responsible for my acts, that's one thing. Okay, it means my acts have consequences. When I say I'm liable for this, it means this act or whatever it is, this proceeding or non-act, when I'm liable for this, then I have um, then it has legal consequences. Okay, that's the point. Well, anyway, okay, so he filed also a motion. A motion is a kind of petition. Okay, petition. Come on, guys. Portuguese, English. Okay. A motion is a specific petition for something. Okay. For example, motion for clarification. Motion for clarification. So if a judge, for example, issues an order or a decision and he is not clear as to the value that should be paid. So there's this case, you're suing someone for having broken your car window. And then the judge gives an order and says, okay, you repair this window. Then there can be the filing of a motion for clarification. That is, hey, judge, come on, I don't understand shit here. Okay, don't. You don't do that to a judge, right? Oh, hey, judge, it wasn't clear. Can you please clarify your decision? In Portuguese, embargo de declaração. Okay. I think in English it's a you see it's simple. Clarification, clarify. It's not embarguei. No, okay. Clarification. But the thing is, motions are those requests, petitions in the course of a civil procedure. So he filed a motion to proceed IFP in forma pauperis. That is to have free to be exempt from legal fees. Okay. And then they mentioned the 28th section of U.S. Code, paragraph 1914, and they give everything. You will see that they mention an amendment. An amendment. They mention an amendment. And to amend something is to correct, something to adjust, something to a new reality, whatever. They mention an amendment by the Prison Litigation Reform Act. They don't say the year. So Congress got together and thought, okay, so we need a prison litigation reform. Prison litigation is more or less what we have like a processo carcerário. Now we don't have this in Brazil, right? But anyway, so they reformed it through an act. An act is a law that has this specific theme, okay? And amended the U.S. code. That's just how it's done here in Brazil, okay? You cannot like just dismiss a code when it is instituted, okay? And then you will see that they give a very precise account of his bank balance and checks and all. So it's really interesting. The guy, by the time he files his complaint, he had like $7 in his bank account. Of course, well, in his name. Okay, I imagine that he was richer than that. But anyway, the evidence he showed to court was enough for the judge to grant his request on the motion for exemption of fees. The opposite of granting is denial, to deny. A judge can deny a request. Okay, because deny is different from dismiss. Okay, dismiss, like I'm not even going to hear your case, right? Which a judge can also do. But once a request is established, you either grant it or you deny it. Okay. Also, you grant. Okay, it's really small, right? Sorry. You grant a relief. Guys, a relief is a judicial provision. Okay, so okay, it's Bob now. How can I say? Yeah, it's a judicial provision. When when Tim Lambesis filed his complaint, he wanted a relief. because he wasn't getting anything in normal ways. Remembering, in an ideal world, our judiciary system is like the ultima ratio. It's, it's like the last resource. So a relief in this case, okay, is like the provision, the provision from provide. Okay. So also there is a remedy. A remedy is like a relief um, to remedy some wrong. For example, a guy is unjustly arrested, so he seeks for a remedy called habeas corpus. Um, Habeas corpus in English is habeas corpus. Okay, it's, well, probably they say habeas corpus, but same thing. Okay, so most of this case is like they discussing whether his request should be granted or denied. Um, and there's a very small discussion, very interesting too, on there's someone texting me. I'm checking it to see if it's Skype. No, it's not. They discuss like precedents. That's a very interesting thing. No, Maria, I don't think. Luis, are you there? Because people are uh, people want their certificates. But anyway, they discuss precedents. You will see that the precedent discussion and application is. I'm not going to read it all here, okay, guys. Also, because there's already 57 minutes. Um, I've I've been speaking, but anyway, they give this um, they give this weight to precedents that's much larger and much heavier than guys. I'm not going to last too long anymore, okay? So if you want to make it available, because we have like 1 hour already. I don't know, but anyway, they were discussing more precedents than legislation. So please read it at home and see for yourselves how this works. It's really cool, and try to have this text smart to see how he how the judge in this case, how he is worried to pinpoint clearly how how all those precedents he is mentioning are going to apply to this case. In a simple case of a motion for IFP, that's really cool, right? It's not like, oh, according to Article 300 of the Code of Civil Procedure, I wrote this like yesterday for a client. According to or pursuant to, see that? Pursuant to code to Article 300 of the Code of Civil Procedure, uh, then you ask for not legal assistance, right? For how can I say, like the free filing. To file is to enter with a case in court, right? Um, so you ask for exemption from fees. It's not like that. According to this law, it's much more direct, right? But no, not here. In this case, the guy looks at the precedents and says, okay, uh, here in this evidence, he shows that he was poor like 8 months before, even before the filing of this complaint and all. So according to this and that precedent, it entitles him to to have this exemption from the filing fees. Yeah, okay, all complaints must, and then he, yes, he mentions lots of things. Let's go to the provision itself, okay? To see what part 3. It's on page 6. It's only 7 pages. This decision, conclusion, and orders. A court order, guys, is a court order. It's law, just like here. Okay. First, grants the plaintiff's motion to proceed IFP pursuant to 28 USC. Directs, because it's not an order. Okay. When a judge is working with a body of the state, for example, a clerk or a marshal official related to, he directs, okay, he doesn't order because he doesn't need to, okay, it's already their job to do whatever they do. So, directs the secretary of the California District of whatever, or his designee to collect the initial filing fee from the plaintiffs. All the trust account. How can I explain this? All prisoners and incarcerated people. I'm not really familiar with this because, like I told you last week, I have a problem with criminal law. But they have like this trust account, a bank account with some assets. I don't know where they get that from. And they balance it and check it until they go out of jail. Okay. Maybe they incur in debt. In some states they do. I know that. In Texas, and, well, whatever. And then he directs California, probably the jail system officials, to proceed to discounts in his trust account. He directs the clerk of the court. Guys, every court has clerks. Clerk is a guy who works helping the judge. Assessor, who does like usually does all the paperwork and the judge just signs, right? But yeah, that's clerk. And when he makes a mistake, for example, he attaches a wrong document to this file, or he fills up a form with the wrong number of procedure. We call it a clerical mistake. Okay, guys, you see my handwriting is a disaster. That's a kind of clerical mistake. Okay, when you type things wrong, things like that, you call them clerical mistakes. Okay, a very famous clerical mistake that occurred this week on Marisa Leticia's inventory. Have you seen that? Well, that was a clerical mistake, big one, but it was. And then he orders the marshal to serve a copy. Okay, now my example is contradicting me. To serve a copy. Guys, to serve is to do service. Wow. To do service, to do court service. Diligências. Okay, guys. So to serve a copy, it's like to go look for the guy to sign the receipt for whatever you're giving him. That's serving. Okay, it's not like serve in a like in a restaurant. Okay, no. Okay, to serve is like to proceed with all the steps you need in order to achieve this specific goal. In this case, serve a copy of the complaint and summons upon the defendants. That is, so what his service is. Find a copy of the complaint and the summons. A summon is a call. Is a call to the case, okay, to litigate. That's what a summon is. Citação, right? All calls of service will be advanced for the United States. Directs the clerk to issue a summons again. As a plaintiff's complaint upon defendants and forward to plaintiff along with, and then he establishes the forms and everything he has to follow. Defendants orders defendants to reply to plaintiff's complaint within the time provided by the applicable provisions of Federal Rule of Civil Procedure. Again, you see this US code here. And orders just plaintiff to serve upon defendants, or if an appearance has been entered by counsel. So you're summoned. You can have a counsel that is an attorney that is going to represent you. Okay. That is not yet an attorney because it doesn't really have a mandate now, up to now, but that's the counsel. And so on, and he finishes with, it is so ordered. It's our, no, not intuition. Well, you got it. It's so ordered. Good cause appearing, where did it show? Larissa. Do you have the page there? It's probably in the beginning, right? Oh, 3. Okay. The beginning of, let's see, good cause appearing, page 6. Beginning of orders. Good cause appearing, the court. Oh, okay. In face of the facts, since the facts are feasible, you know what this word means, plausible, okay? Since the words are plausible, there are precedents applied or applicable to that, then there is a good cause. A good cause appears, so I give the order. Okay, that's the expression they use. Okay, so it's like in face of the facts. Remember, our judges here in Brazil, they use this. It's in face of the facts. It's something like that. Diante do exposto, pelo arguído. No. Well, you got it. That's good cause appearing. That's it. After all this I said, and I mentioned, and the application of those proceedings, and on and on and on and on, there's a good cause. So I order. Okay, that's it, guys. I will leave this for you for homework. This material, I promised you, is almost ready, and it will help you to work out with some some of the material difficulties you might have, like vocabulary. Okay, But it's really cool. What I want you to pay attention to, which is the most important, is the construction. Okay, the follow up of ideas, like how he sews his text. It's really cool. And when reading, try